This is the Keep Right column by Ralph K. Ginorio, as published online by the Coeur d'Alene Press, May the 5th, 2022. Lawmaking, Return to the Legislature. In their landmark 1973 Roe v. Wade decision, the United States Supreme Court took into its own hands the power to make abortion on demand the law of the land. This is not how our constitutional republic was ever designed to operate. State legislatures and the United States Congress have the responsibility for making law. That is why we elect our state and federal representatives and senators to act in our stead to establish laws rooted in the Constitution and inspired by the popular will. The president and state governors have increasingly intruded on this prerogative through executive orders and bureaucratic regulations. Activist state and federal judges have also stepped beyond their legitimate judicial role in making law from the bench. In 1973, the Burger Court asserted a non-existent right to privacy as the basis of their decision, which legalized abortion on demand in all 50 states. This short-circuited the constitutional legislative process. The intensive politicization of our Supreme Court has been a direct result of the Roe v. Wade decision. Pro-choice advocates have seen this single Supreme Court decision as the indispensable foundation of what they call reproductive rights. This is why Senators Joe Biden and Ted Kennedy engaged in an unprecedented demagoguery to torpedo the nomination of Robert Bork in 1986. This is why Senator Biden engaged in a 1991 media circus, which nominee Clarence Thomas called the high-tech lynching of uppity blacks who deign to think for themselves. This is why in 2019, Brett Kavanaugh was smeared as a rapist, and why in 2020, Amy Coney Barrett was libeled as a religious fanatic. As we also see in the leaked Alito decision today, any crime or travesty is justified by pro-choice advocates if it serves to defend Roe v. Wade. What should be our most deliberative and least political branch of government has been dragged into the no-holds-barred street fight that is contemporary partisan politics. Abortion on demand should never have been unleashed by unelected Supreme Court justices who are appointed for life. It is an issue that deals with the most intimate elements of what we believe life and liberty to be. Some believe that since 1973, Roe v. Wade has caused the murder of more innocent human beings than were killed by Joseph Stalin and Adolf Hitler combined. This would make the post-Roe United States only outdone by Mao Zedong in the catalog of history's top mass murderers. I hold this conviction. Others believe that the unborn baby is a subset of the mother up to a certain moment before birth, and therefore is not worthy of the independent human rights accorded to those who live in the United States. This qualifies abortion as a mere discretionary surgery, akin to removing a growth. Those who assert this view say that choice of the would-be mother is the only priority in such a case. Many accept that abortion is a horror show for everyone involved. It is a tragedy under the best of circumstances. However, if the life of the mother is at risk, or if the child is the issue of incest or rape, many can understand why abortion might be chosen, especially within the first trimester of the pregnancy. In such cases, what might be done is a matter of gravest consideration between a doctor and all concerned. I also happen to hold this view. Now, we will each have the opportunity to advocate within our states for what we believe is right, true, and best. Different state legislatures will arrive at different conclusions. People will then vote with their feet, traveling to jurisdictions which align with their convictions. This is all as it should be.